Okay, good afternoon. This open meeting of the Board of Appeals is being conducted hybrid pursuant to Chapter 2 of the Acts of 2023. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will not feature public comment. For this meeting, the Town of Nantucket Zoning Board of Appeals is convening in person and by video conference using Zoom as posted on the town's website, identifying how the public may join. Please note that some attendees are participating by video conference. Please be aware that other people may be able to see you, and take care not to screen share your computer. Any supporting materials that have been provided members of this body are available on the town's website unless otherwise noted. The public is encouraged to follow along using the posted agenda unless I note otherwise. So I'm going to call to order this special meeting of the Town of Nantucket Board of Appeals. What's the 19th of March at 1:06 p.m. I don't have a copy of the agenda, but it's 025 24, Surfside Crossing. Thank you so much. Yeah, 02524, Surfside Crossing LLC. Our public hearing closed March 4th, 2025. We have our decision action deadline for April 13th, 2025. And at this point, the board is beginning our deliberation. Okay.
And Madam Chair, I did want to
Yes.
mention Attorney Pucci is online.
Thank you. Okay, so we've closed our public hearing. We've taken in all the information.
Did we get any, we haven't gotten any further information that we were waiting for that we could maybe reintroduce?
No, I don't believe we've received any,
We haven't received anything new.
not that I've seen. Billy, do you have any
Well, whether or
update?
not, the update from that, I'm gonna forget the name of the company though.
Bristol Engineers.
Bristol Engineering, and there was one other thing that we thought might come
No,
in.
the letter from Bristol Engineering was that the earliest we would see a review, I believe, was March 31st, was what was in their letter. The only thing we did receive was correspondence from the fire chief.
And he is submitting the request, he just needed drawings.
Correct,
And
which
you
I
got
did.
those?
I forwarded those to the fire
So
chief.
those are the two things that we were thinking we might get after
Yep.
the fact. Okay.
So at this point, do we want to start talking about, we can do two things. We can start talking about how we see this going, either an approval with conditions or a denial. And if we are inclined to approve with conditions, then we need to start talking about what those conditions are and how we think the project will look, or if we are going to move in the direction of a denial. So we can start that conversation. We can ask George to give us a summary of how that looks for us. It's up to you guys how you want to.
I mean, I think getting people's feelings on which way they're leaning makes sense, because there's not any reason to talk about a bunch of different conditions.
Oh, yeah, if we're moving towards denial,
Moving
yeah.
towards denial. So,
Yeah. Okay, so do you want to start off that conversation?
Sure, I mean, I think,
And put you in the hot seat?
I think, given the testimony regarding the unknown issues associated with the water quality and and the other potential dangers, relative to fire, the single access, all of those things lead me to the conclusion that those potential risks do not outweigh our need for the density, this project. I can be convinced otherwise. I do have a bunch of things circled for conditions if more of the board wants to go in the opposite direction, but I think it's just very hard to, if you know that there is potential to damage the aquifer, and nobody's going to know that until it's too late, how can we approve a project? without any guarantees that at least provisions have been put in place for something with the Hupple, I think it's Hupple, right? You know,
Luppel?
Luppel, thank you. You know, that hasn't been disproven, and without, you know, understanding or other ways of mitigating that, maybe more rain gardens, you know, other ways of mitigating the potential runoffs. They haven't come back with any other suggestions, so I just feel like at this point, I don't see any path to agreement. So I would probably move for a denial.
Madam Chair, I'd like to follow that up with,
Sure.
I completely agree, except for the part I can't be swayed in any direction at this point of the hearings. They've had plenty of time, plenty of chances and opportunities. They have the resources with all the experts. They have not come forward with any suggestions on a way to remedy our issues, the town's issues, the abutters' issues. They're showing zero effort in reaching across the aisle on this and making anyone comfortable, especially with the water quality, the access, the possibility of fire and the dangers of that, the traffic, the density. There are just too many negatives. I don't see that any conditions on an approval. I think we're all pretty aware that if they were willing to negotiate and meet us halfway on anything, they would have by now. So I see this as a very much a clear denial on my behalf, which I've made clear through many meetings. But I just think an approval with conditions is a waste of everybody's time. Thank you.
Thank you. I haven't said much during this hearing, but I've been taking in as much of this testimony as I can. I tend to agree with Lisa and Elisa, and frankly, I would hang my hat on the stormwater standards. I think that is the bigger. We've heard a lot of reasons to deny or why we shouldn't be in favor of this, but to me, that one is the strongest reason not to approve this project. And I think that we're at the point of a denial, since it doesn't seem to be that we can come to any sort of compromise. And I do think that an approval with conditions is not going to work in this instance.
Jim?
I echo what the three previous board members stated, and including John's, view of these water issues being front and center. We did have peer reviews from other town boards, and a lot of them had problems with this as well, so it's further evidence. So, the Board of Health obviously was the biggest in terms of this water issue. The members of the fire department or previous members, clearly stated their concerns about this. The HDC had changes that, they weren't willing to make any type of design changes. Not that that's critical, but I just think these changes don't, or I think our need for affordable housing is trumped by some of these local concerns. And can I ask George a question?
Can I say my opinion first?
Oh, yeah.
Yeah. So I agree with everyone on the board. I think there was a time where I was hopeful that we would get to a decision, an approval with conditions. But as the process went on and there was no movement by the developer to mitigate the concerns or make any changes on the plan, including, Jim, what you brought up, HTC, yes, those design changes aren't critical. So those would be somewhat easy changes to make to try to meet some concerns of the community. And those weren't addressed either. So it's hard to move forward looking at an approval with conditions, especially with the LUPL and the stormwater standards. And I think we do have a lot more information now than we did. And putting a development of this size in an area of concern would have or could have island-wide detrimental impact. So I think we're all pretty much in agreement for the same reasons, the health, the safety, the secondary access, the concerns from the police department, the fire department, the Board of Health, water, yeah, and just not having any of those, I don't want to say taken seriously, but I don't feel that there was really wasn't any effort on the developer to come back and try to change the plan to address those. And unfortunately, I think if they had, we could have possibly gotten to a decision with conditions. So, okay.
Can I
Do you have a question for George?
Well, yeah, and then I want to make a couple more comments.
Sure.
George, so if we deny this, so we're really denying substantial changes? So what does that, how does that leave things? Does that go, I know we've talked about this, but sorry, I'm being obtuse. But do we go back to our original permitted plan? That's the option? Because these really are, they're only substantial changes, supposedly.
Yeah, I think if you were to do a denial, that's just what would be on appeal. It's the denial. I don't think it would reenact your prior approval with conditions because that was stricken by HAC. So there's no operative permit right now. Your decision was stricken by HAC and then Superior Court struck the HAC decision. So I think that it's a little bit procedurally unusual, but my position at HAC would be we're defending a denial of the project change, which essentially results in a denial of the project.
Okay.
And it's a project change from our last comprehensive permit, not from what they originally submitted. Because that came up a lot during the hearing. It was like, well, it's not that different from what the original project. And it's like, well, no, not the project that you submitted, the project that we approved in our comprehensive permit. So I just want to understand that original change in scope back to what they originally wanted to build wouldn't become allowed.
Yeah, actually, it is that. That was what was remanded by the Superior Court. In other words, the Superior Court ruled that the HAC should have sent it back in the first instance, comparing their original project proposal with the project change. Because remember, you would actually not have even issued a decision at that point because, you had issued a decision and then it came up at HAC that the developer made the project change and then they refused to remand it. But that is what the change was before you, comparing the original project proposal with the project change. And here you had the unusual circumstance that now you've had additional information come to light because of the passage of time. and the board is focusing on denying the project as proposed, in the project change. So that's what you're going to end up having is a denial. If you wanted to revisit your approval with conditions, you could. I mean, you could reenact that yourself, but that would end up being an approval with conditions. In other words,
Right.
that would be your action in the project change, would be the approval with conditions. But it's sounding very clear from the board that you do not want to do that. You don't want to issue the 60-unit approval with conditions or, a modification
No.
thereof.
Yeah, I don't think so. I was just making sure that then, if anything were reinstatable, it was their first request to us from which we came up with our first comprehensive permit. So it would involve the single-family residences. I think there were 6 condo buildings, remember? So it would go back to that.
Yeah, what would end up happening is that it'll be it will be either the HAC is going to overrule your denial and give them what they want on the modification, or they will uphold your denial, and then there's no permit at all.
There's no permit, even the old one is defunct.
Even the old one is out. Correct.
And
Oh, go ahead.
I was just going to say, what do you think our chances of that at the HAC are?
I
Of
think
getting them to, agree with our denial?
Yeah, my advice to the board would be if you think that there's evidence on the record that justifies the denial, that should be your decision. And, and then we'll defend it. And, to address how HAC may or may not rule on that, I don't think I'd want to have that conversation with you in public because it goes to litigation strategy. And then,
Okay.
how a superior court might then rule on an HAC decision is also another issue, and whether you would have further appellate issues. So you'll have to see how that plays out. But again, I can't emphasize enough, if you think that there's evidence in the record that compels you to deny this project, you should do that. And we'll defend it, and whatever happens on appeal happens on appeal.
George, I did want to follow up with basically what Lisa said, and this might be repetitive, so I'm sorry if it is. But so I guess I don't understand the process. Once we all vote to deny this, which it looks like we're going to do, what is the process after this? What's the timing? When does it get taken to the HAC, and who are these people, and where are they, and when do they make the decision? And then when does Superior Court step in, or I just don't understand the legal process.
Yeah, I think the HAC would be up to the applicant to go to the HAC, correct?
Is that true?
Yes.
I don't know how it goes.
So the rights of appeal are if the developer is unhappy with your denial, or if they're unhappy with an approval with the conditions that are imposed on an approval with conditions, their right of appeal is to the Housing Appeals Committee. And so the Housing Appeals Committee is a state administrative agency that adjudicates appeals of 40B decisions, a developer appeal, not an abutters appeal. So
George, what's that timeline like? Because
They-
obviously, because he has all the infrastructure in, everything's underground, ready to go, I would, if I was a betting person, I would bet the developers were going to appeal this decision. And I'm just wondering, again, what that timeline looks like with HAC, and if there's any further intervention that can be done as a
That's-
board?
yeah,
or
that's
from the
within-
community?
Right, that's within the month of your decision that they would have to file the appeal with the HAC. They cannot proceed as of right in the event of a denial. Remember, before they were attempting to proceed as of right because you did not have any pending litigation against them. They just had abutter appeals pending. And they had a decision from the HAC, and they were proceeding as of right. Here, they would have an appeal of your denial decision if you go ahead and that's the consensus that you want a denial decision. They cannot proceed with the project while that appeal is pending at
Right.
HAC.
So when would it get to the Superior Court level?
The HAC would conduct a administrative appeal of the developer's appeal. And what that process consists of, they'll have an initial conference of counsel. They'll offer an initial free mediation session through their mediation service. If the developer or the board does not want to mediate, then the case would go forward to a schedule for the filing of what they call pre-filed testimony, which essentially look like affidavits. But what pre-filed testimony is it substitutes for, if you would envision a regular trial where you ask your own witnesses Q&A, you do that direct testimony through a filing of a written pre-filed testimony. And then they schedule a hearing date where any party that, if one party wants to cross-examine the other party's witnesses, that is what occurs at the administrative hearing. In other words, only cross-examination on pre-filed testimony that was previously submitted. At the end of that process, the parties will file post-hearing briefs arguing their position. And then the HAC, the presiding officer that hears that appeal, will issue a proposed decision to the full HAC, which again is a state administrative agency consistent of various state officials. And then the HAC will issue a final decision on that. That decision is then again subject to further appeal. In the event it was a finding against the ZBA on the denial decision, you would have the right to seek judicial review. So that's when that appeal process would go forward. But still, first you need the administrative hearing and decision from the HAC in the first instance.
Thank you. One follow-up, so is there a person or a board or a way to contact the HAC? I know a lot of people in the community are against this project. I don't know anyone that's in favor of this project. And I'm being asked, is there any way that people from the community can reach the HAC, write them letters, do something to further influence the outcome of this and let them know their disapproval on that level?
Yeah, they're a state administrative agency, so individuals wanting to communicate with them would have to decide when and how they want to do that. They could write them. There's a process with HAC that when the appeal is filed, interested parties would be able to either seek interested party status or seek full intervention in those proceedings. So here you have, you'll recall that the Land and Water Council has, given expert testimony in this process. My guess would be Land and Water Council would file for a formal intervener status. Probably the group that Attorney DeRensis represented, I would imagine, would be also full intervener status. And actually, I don't even think a motion would be necessary in those instances because they were already full interveners when the HAC sent this back to you. So they're already parties to that. Other people, I would hesitate to give any advice on that. They'll just have to review, what it is. If they want to seek, advice from an attorney, they can do that. And, again, they would have to decide whether and how they want to communicate to Housing Appeals Committee. But again, it's a state administrative agency that is, you hit Google, they come up. There's no problem at all. You can see exactly who they are. They list the regulations that they enforce. They're a state administrative agency of the Housing and Livable Communities, which is an executive office of the Commonwealth. So those individuals who have contacted you, and I would recommend everyone on the board sort of defer communications with third parties while you're deliberating on this and issuing a decision, just so that there's no issue of, any type of undue influence outside of the public hearing. And I understand you live in a small community, you might bump into somebody in the supermarket or anything like that. But
Happens all the time.
yeah, I would just recommend that
You wouldn't believe how much.
to err on the side of caution, I would recommend that you just advise people you're not free to talk to them about this while the deliberation process is going.
Okay, thank you.
Comment. So the reason, why I asked the question is because about the, what is this? Is this a change or not? It might not be a de facto, or it might not be an official new project, but for all intents and purposes, it is in a way. And I think that's an important factor because I know we've gone back and forth whether things have changed and how you measure that change. But I think considering that and considering, as you've stated, George, the time that it's taken, things have changed, especially with PFAS. I think we didn't have any information on the affordable housing, but I think we're in a much better position than we were, and we might even be considered in safe harbor. But I also think that some mention needs to be made too. And I've followed this from the beginning, but I think there's been some bad faith operation by the developer, by basically going through the process with us and then not just making some tweaks, and I know they have the right to do it, but they basically came up with a whole new project. And that to me is gaming the system. And if you allow this to happen, then every developer in the state's going to take this tack. They're going to go and do a little kabuki dance with the zoning board and then go make a change and hope, as they did here, that the hack will say, oh, that's no big deal. But this was a big deal. I mean, this was a big change. And you know, I don't know how that factors in. Maybe it doesn't, but I hope that point is made in our decision.
Yeah, and I think I agree. I mean, it wasn't necessarily from their original proposal a big change in quantity of units or people, bedrooms, but they got rid of the double access. They got rid of a fair amount of green space that had been,
All the single
residential houses.
Yeah.
I mean, it was a big, substantial change, and I think it should be clear that we're not talking about density necessarily, because I think the number of bedrooms didn't change, but it was really about how the site was treated. This, you know, the scale of the buildings and how it related to the neighborhood was very different. The single access, which to me is a real big factor, was eliminated, and you know, the community building was, you know, 1,000 square feet, maybe it was bigger than that, but it's much smaller than what they're proposing now. So there was that big kind of, it felt like a lot more open space.
And that's why the water quality is the biggest issue, because it really changed the water quality issue.
Yeah, there were no rain gardens or natural.
Yeah. And also along those lines, I guess directed at the board, you know, they clear-cutted the thing.
I was just gonna say that.
You know, again, they're not working with the community. They never wanted to work with the board. And they work with some people in the community and some other boards, and that also is an issue with me, that you kind of they continue to backdoor it with the Affordable Housing Trust, with the Select Board, who knows? And that, again, undermined everything we're doing, and I just think that needs to be brought up as well. And I don't know how much weight it has, maybe with, you know, down the road it does, but.
And how did they, I just don't know the process, but it's seemed pretty presumptuous to not only clear cut the whole property down to absolutely nothing, when we do so much in this community to protect this island and all the natural things that grow here. You know, just, I know this doesn't have a lot to do with the application, but the behavior so far is so presumptuous that if that's any indication about as to how the rest of the project is going to go and how the developer is going to conduct themselves, and then putting all the infrastructure in, I don't really know how that was all approved and done and
At their own risk.
allowed at their own risk, but something seems very wrong about that too. It should just be an uncleared piece of property at this point. They haven't gotten the approval. And I I have a problem with the general attitude coming from the developer, just like, we're going to do what we want. We're not going to make any concessions. We're going to chop every living thing down. We're going to reshape the land. We're going to put tons of utilities in the ground, because as soon as you get through this process, the board, the zoning board gets through the process, we're going to slide through HAC, and we're going to build this thing. And, I worry that our time spent here has been a waste of time, and I really hope the HAC has some way of listening to this and really thinks long and hard about their decision. I think it's highly sensitive and frankly dangerous to build this.
So I understand, and I hear the parts that you guys are saying, Jim and Lisa, about bad faith and, moving forward at their risk and clear cutting and all of that. And those are concerning. I do think that if we do issue a denial, we need to focus on because all of those things may be true, but if there wasn't the stormwater standards that we felt were being violated or not met, and the health, safety, and welfare of not only the community, but the people that are going to live in this development, I think we'd be more talking about approval with conditions, even because those things may be happening or allegedly may have happened, or we may feel a certain way, but that doesn't, those alone don't give us, or those aren't reasons to deny the project. And I think we need to focus on what we originally said on that first, where do we feel that we're at, which focused more on the stormwater, the emergency access, the concerns that have been brought forward by the Board of Health, the sewer department, the DPW, the fire department, the police department, and the HTC and the neighbors and all of that.
Yeah, no,
No,
I agree.
I totally agree. I don't think we could stand on any of this, but that's why I made this point after, is that I do think it should be addressed in some way, and whether they take that into account.
Can it just be part
Or
of the
not.
narrative of how we ended up at the denial?
I think maybe maybe if we have a conversation with George in executive session, that would be a strategy. If we get to that point, then we could talk about that. But I think that council will, in drafting the decision, with the experience that he has with HAC, will
Include the sort of.
will include what needs to be included to put our decision in the strongest light possible.
Yeah.
I imagine if it goes to an administrative hearing, or if it goes to appeal, or all of that, some of this other stuff might come in, but I'm not sure.
I think, can I just interject, Susan,
Yes,
do you
of
mind?
course.
I do think you should end up with a denial decision that you're comfortable with, and if you think that there's relevant background that should be included, we can certainly include that. I don't mind having that conversation in open session, about what should or shouldn't be included in the denial decision. I do think that you need to all be comfortable with what's in there, and if you think that there are issues about the background of it that are relevant, I'll certainly attempt to draft those, and then the board can look at that. I hesitate to make editorial comments, but honestly, I do a lot of this stuff that involves environmental issues around housing. I don't do commercial developments, but I do a lot of housing related stuff that involve, the Wetlands Protection Act and issues like that. And to be honest, I don't approve. I don't sort of give my good seal of approval as an attorney on the clear cutting issue. That was done, admittedly, and I don't mind saying this publicly. That was done in a very aggressive manner on a weekend. I remember being alerted by a bunch of text messages that was going on. And that's just not, that's, I always try to get people to act neighborly, and that is just not a neighborly type of thing that you go in, you make sure that you sort of cover your bases in terms of what they thought they could get away with doing that. And, go in on a weekend, like I say, not really give anybody notice, and then have people that are quite upset justifiably because they don't really know what is going on or under what right that they're doing it, to try to figure out and catch up, as to why that was going on. So that, admittedly was not, as far as I'm concerned, that was not kosher behavior, and I don't, and that's why I say I do a lot of this, and I'm not into clear cutting, and yeah, you can have the right to proceed at right when you only have a butter appeals or the land council appeal pending. But the fact is it's very aggressive behavior to go in and clear cut a site, under an as of right type of scenario. So that, I totally understand if the board members, want to have a little bit of the background in this. Yes, you're correct. HAC will not focus on those types of issues. They will focus on the evidentiary issues, through the expert testimony on these issues of importance. But, I certainly would not get in the way of the board if they want information about, the background on this without, being too flowery in our language or anything like that. But if those are concerns that the board wants to put in terms of background or a narrative, as to the background of this, I'll certainly try to do that.
Yeah, Madam Chair, and I, that's what I'm getting at here, and I think George will know what to, how to, George will know, how to phrase it, that will have some influence
Yep.
on them.
Okay.
So, Madam Chair, if I may, so I think we're all generally on the same page on this one, or at least there's a lot of the overlap in the Venn diagram of all 5 opinions.
Yeah.
So what are our next steps?
So George, if we want to do a vote to deny the project and for the reasons stated at the beginning, or we can craft them back out into a motion, do we make that motion today and then you would start drafting a decision, and our next meeting we might,
Wouldn't we draft the decision and then vote on that?
Yeah.
Like go into executive session, discuss it further.
can we go into the executive session for that? I don't think so, because it's not in litigation.
Can I just say what I'd recommend? And then
Yes.
you can do what
Yep.
you want.
Thank you. That would be great.
Yeah, you could go ahead and vote today, but I mean, I think I'd have to have my audio shut off to not understand what the consensus of the board is, what you want to see in terms of a decision. So what I'd maybe recommend would be you have a further deliberative session after I provide a draft denial decision to you.
Okay.
And then you have a deliberation session focused on that, I think you should have added X, Y, Z, or I don't like the way this is worded, or I have some revisions or whatever. And then I can take that and prepare, a final decision based on your input on my initial draft. And then perhaps, vote that final decision at a further session. So what I would envision would be at least 2 more sessions of deliberations. The good news here is that you don't need a lot of deliberation sessions because your consensus was so clear at the beginning. A lot of times boards will need, a couple of deliberative sessions before they reach consensus. Here you reach consensus pretty quickly, so I can get to work on a denial decision. And then if you have at least planned out 2 further deliberation sessions, I think, in my opinion, that should be sufficient. You look at that initial draft, you give me your questions and comments on that initial draft, and then I prepare a proposed final draft for you to vote at that final, what would hopefully be your final deliberation session. So hopefully that makes sense.
Yeah, that makes sense to me. When would you be able to have a draft?
Yeah, I mean, let's talk
Madam
about
Chair.
dates. What would work for you? And then I can figure it out.
So we were talking about meeting,
Yeah, this is a good
March-
time for me to jump in.
Thank
And
you.
George, let me know if this is enough time. So I had emailed the board about meeting next Wednesday, March 26th.
Yeah, my initial preference was the 31st, but I heard from Billy that the board members can't do that. So my if you tell me the 26th is the best date for the board, then I'll get it done. I'll get you
Are
the
there-
decision beforehand. If you can meet, on a little bit later of a date, like, the first week in April, I could have that to you in advance. And I remember we could also schedule, you wanted to have an executive session on the McDermott matter, which I would recommend that if you could do both of those, because I would be in person for that one.
And when
But
does
if-
that one have to be done by?
We have to provide a joint status report to the court by April 7 on the
Okay,
McDermott
so we have
case.
time on that too.
Yeah, so
My
if-
preference would be
yeah.
to not do the 26th. I just have a conflict, I can rearrange it. But if George isn't ready, then why don't we schedule it into after April 1st?
If I, and Susan, sorry, I'm just sort of talking directly. I would prefer a little bit later than the 26th. There is a lot, I obviously have been part of this and I know what the issues are. I know where the main issues that have the expert opinions in them are, but there are a number of comments and quite a large record that I would try to make sure we get everything that you'd want to have included in there. So I could actually use a little more time if you could make, the first session, maybe the week of April 1st. I don't know if that's possible.
Billy, what were the dates that you had?
Okay.
You're way
So-
after that? I'm just away that day. Okay.
We could still meet March 31st if that works.
That was from, I don't,
So
No, I'm off island.
you're off island?
I think, we get a better product.
Yeah, let's give George the time he needs.
Yeah.
What about could we do this Wednesday, the 2nd? Was that an option?
It wasn't one that I looked
Okay.
into. I mean, I will make it a reality either way. I know George wanted to be here in person. That's the only thing where it gets a little tricky. I could always do something on Zoom. But
I
we were
only
executive
wanted,
session.
I only wanted to be in person just so that you had me in person. It's
Okay.
easier to, but it doesn't, that's up to the board.
and we can still do executive session over Zoom, or no?
Correct.
Oh, we can?
Yeah.
Okay. Yeah,
The
so-
only, we have to go date and time certain. So I think if the board wants to do April 2nd, do we have a time, 1 PM again? Why don't we set that up?
To be in this room though, because we don't have an audience?
I think because of the audio.
The NCTV involvement is why we're here.
I see.
Do we want to do earlier on the 2nd instead of 1? Do we want to do like 11? Or is that,
I haven't looked into something like that. 1
Okay.
o'clock, we could almost always pull on a Wednesday in here because select board's in here in the evening. And then the following week, I looked into the 7th, 8th, and 11th because we have to be done by the 13th, which is technically a Sunday. And then also keep in mind our regular meeting is Thursday, the 10th. The 11th, when I reached out, wasn't an option, so I have the 7th or 8th for that following week for us to meet
Why don't
one
we just
last
do the-
time.
So you don't have the 9th, which is a Wednesday.
No.
the 8th, I'm off island.
Could we just do that Wednesday?
I bet we could. I didn't look into that because I didn't know, setting up back-to-back meeting dates. I didn't know if you all want to do that. Wednesdays haven't seemed to be a problem because select board here.
It's a problem for me, Billy. I have
Oh.
another 40B that day
Okay.
that I wouldn't be able to, although I could join you remotely that day if you wanted. If I come in person on the 2nd, maybe you don't need me in person the second time.
Yeah, no, I think,
No, no, but we have to keep minutes for executive session.
But we could do that in a different room? Potentially, because we don't need NCTV?
Sorry,
We can do executive session in a different room?
wherever we, like, if we were to have executive session, yeah, we could move to,
Oh, but we have to have an open meeting to.
you have to open a public
vote.
meeting, then
Yeah, yeah.
adjourn into execugetting session.
Well, can we do Tuesday, so we could do
Why don't we
Tuesday
set
the
up,
8th?
we're gonna do 4-2 as the next meeting at 11 or 1. I'm getting texts from, luckily, higher above here. 11 a.m. would work on the 2nd,
I can do
on
either,
April
whatever
2nd.
everybody's preference is.
Is that cool with everyone? You want me to make the choice?
no, no,
And-
I
and-
mean,
and is George joining us on that one?
George, you said you could be available on April 2nd in person, correct?
Correct, yeah.
so then why don't we
Yeah,
do
let's-
1
yeah.
and give him time to get down here?
We'll do 1 o'clock, and then keep in mind too, we're gonna adjourn into executive session at that meeting for the Monomoy issue.
Yep.
Yeah, just to be clear, Susan, just to be clear, because I know you have a lot of interest in this 40B matter. The executive session we're talking about is the litigation in the entirely unrelated McDermott versus
Yes.
ZBA matter. It's not for this.
Not for Surfside Crossing.
Just want to be clear, you're going to
Yeah.
definitely conduct these in open session, the deliberations on Surfside.
Oh, yeah.
And then how does Tuesday, April 8th look? Anytime?
I'm off island.
Oh, that's right.
Does the 11th work for everyone? We technically are supposed to be
here.
done by the 13th, which is that Sunday. The 11th would be the Friday before then.
Well, presumably, we will have done all the heavy lifting on the 2nd.
That's what I'm thinking. This is gonna be a one last meet. We've read the decision and we want to sign it. That's what the
Yeah.
final meeting should
So let's
look
just do
like.
the 11th. Let's make it as close to the 13th as possible.
And do we want to try to do a 1 p.m. there?
So
And then
1
we
PM
have
Friday the
time, If
11th.
there's any issues, we're just continuing right now to the 2nd. We can adjust that later date.
Okay, so we should have a draft decision on the 2nd for the 1 PM meeting. And then we'll hopefully have a final decision to vote on for the 4/11/25 meeting. And our regular meeting is 4/10/25 at 1 PM.
Yep.
And on the 11th, we just have to sign it, doesn't need to be recorded or anything by
I
that
would-
date.
Could we tack the 10th? We tack this on to the 10th and not have to come back the next day?
Maybe, well, it just gives us an extra day in case something goes awry. What I don't want to do is miss the 13th,
Well, on the 2nd,
We can always decide on the
we can
2nd.
continue to the 10th, maybe.
because we're going to be here anyway.
We're gonna be here for the regular meeting, which
Okay.
I gotta review it. I don't think we have an overly packed schedule that day, so.
We
let
just
me-
have all the, yeah,
Yeah,
we're
That
good.
makes sense.
Okay,
What, we have until the 13th?
yes.
And that's a Sunday.
So you're right. So how does that work, George? Is that really Monday?
Yes, it by statute, it falls to the next day, next business day, 14th.
We could always, that's,
We could always make changes on Friday if we had to.
yeah.
Yeah.
Yeah,
I can
that's
get-
what I would reserve, because I'm going to reserve that in my calendar. I'm going to reserve the 2nd and the 11th. And then that'll give you to the 14th to file with the town clerk. I would anticipate, I'm going to give you a very thorough draft decision for your deliberations on the 2nd. And I know that you'll be thorough in telling me anything you want edited or added. So I would anticipate that you're going to have a real, final that you could literally vote, and sign on the 11th. So,
Or the 10th at the end of our regular meeting?
yeah,
Maybe.
either one.
You won't be here the 10th though, George, right? For the regular meeting, there's no reason
Correct, I won't. But I could join you that afternoon if you ended up,
via Zoom.
yeah.
Okay. Okay.
Okay. So then we just need to, does anyone have any further questions for either, or comments for George or for staff or for, about this? Okay. So then we-
Susan, something
Yep.
very important I can't tell, the board members what to do. I would recommend very strongly if everyone could attend who is a voting member on that last STR issue. If you could attend that executive session would be really good, because then we could talk about a consensus of what position you want me to take in that. Is,
See if Joe Marklinger is available.
Okay.
He's
so
already.
even if people have to join in on that by Zoom, you could do that. You could
Okay.
enter in,
The second.
That's
For
gonna be the
second.
yeah.
Yeah.
Okay. Okay. Thank you. So at this point, if there's nothing further, we can take a motion to continue to April 2nd at 1 PM.
I'll make the motion.
Second.
Okay, so Lisa makes that motion, John seconds, and since we're all here, all those in favor say aye.
Aye.
Aye, okay, so that motion carries. So we will pick this back up on April 2nd at 1 PM in this room.
Then I'll make a motion to adjourn.
Second.
Okay, all those in favor say
Aye.
aye. Okay, motion to adjourn. Okay, thank you, everyone. Have a great rest of your day. We'll see you on the 2nd.
Billy, I was supposed to get you to bring some sign applications.
Oh, do you want to follow me back over? Or you
Okay,
gotta-
do you have it in PDF format?
They're all the